Hello, and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. I'd like to talk in this particular video about the preference system. A lot of times I have people come into my office and they say, "Oh, I petitioned X number of years ago for so and so, and just got the approval, and now what do we do?" Um, and there's not an understanding of the different preferences under immigration law, the years that it takes for a visa to become current, and the procedure that needs to go forward. First of all, you have to understand that under a family preference system, there are four different preferences. And essentially, the higher the preference, the quicker the process takes for a visa number to become available. Now, just so you know, there's only so many visas that are issued per year by the United States. And once those visas are used, a backlog starts creating of an overflow. And as the years go on, that backlog becomes bigger and bigger and bigger depending what country you are from. So here's a brief overview of the preference system. First preference would be sons or daughters of U.S. citizens, okay, who are not married. And by sons or daughters, that would be defined as somebody over 21 years old. Then second preference is divided into two sections, 2A and 2B. And second preference deals with lawful permanent residents, 2A being spouses of lawful permanent residents, and 2B being children of lawful permanent residents, and children would be defined as someone under 21 years of age who is not married. Then there is the third preference, and that would be married children of U.S. citizens. And then fourth preference, that would be siblings of U.S. citizens over 21 years old. Now, just so you get an idea of how long it takes, depending on the country, if you happen to be a fourth preference petition, which is a sibling petition from the Philippines, the current wait is about 22 years for it to become current. So, Sister A could file for Sister B today, and that might be approved in 3 months from now. Okay, by being approved, the I-130, it basically shows that the petitioner is a U.S. citizen, that the beneficiary lives in the Philippines, that the relationship sister-sister is correct, and so forth, and they approve the petition. It does not mean that because the I-130 is approved, that you can now go and bring your sister in when the visa waiting has another 21, 22 years. So you have to look at the visa chart. You have to see what the current priority date is. That's the date they're processing. And then, if that is current, then you are able to either adjust status or do consular processing, whichever comes first. And keep in mind that in some cases, if you're a U.S. citizen, it will take faster than if you're a lawful permanent resident, but in some countries, that's backwards, and in other countries, it's almost exactly the same. So you just have to be aware of those facts as you are petitioning your family members. Okay, thank you.